For the first amendment this morning, I want to recognize the gentleman from Ohio, Mr. Space, for what I think is one of the most important and significant amendments that we're going to have to this legislation. Mr. Space, you have an amendment at the desk. I'd ask unanimous consent. I'd ask unanimous consent that the amendment be considered as read, and I'd like to recognize a gentleman from Ohio, Mr. Space, for 5 minutes.
Thank you, Mr. Chairman. As all of us know, this bill allocates emissions to electricity local distribution companies, the specific nature of which are located on page 553 of the bill in its present form, as well as to natural gas local distribution companies, which are located on page 554, both within section 782. The purpose of this amendment, which is being circulated as I speak, is to clarify and make certain that these allocated emissions or allocated emission allowances remit directly to the benefit of retail ratepayers. All of us have concerns about the effect that this legislation may have on consumers generally, and this bill has made numerous attempts to mitigate those concerns. This amendment helps to specify and again make certain that these allowances in particular are intended to benefit and will indeed benefit the retail ratepayers. The amendment affects not just the submission of these allowances, but also the auditing provisions of the bill itself. I think it's a positive change in all directions, and will provide some level of protection and assurances to the little guy out there. Yield back, Mr. Chairman.
If the gentleman would yield to me on his time, Mr. Space, I think this amendment will reinforce one of the central policies of this bill, and that's protecting ratepayers. Our bill requires that allowances given to electricity and gas utilities must be used for the benefit of retail ratepayers. And this amendment strengthens these important provisions by making this policy even more explicit. For example, under the bill's allowance distribution provisions, EPA is required to audit a representative sample of electric distribution companies. Under the Space Amendment, it would be clear that these audits will be focused on ensuring that emission allowances have been used exclusively for the benefit of retail ratepayers. The heart of this bill is the protection of the ratepayer. The Space Amendment strengthens the provisions that are already in place, and I would certainly urge my colleagues to support this amendment.
Mr. Chairman.
The gentleman yields back his time, and the chair will recognize Mr. Barton.
And I'll be happy to yield some of my time to Mr. Walden. Ask the council a question. Could you define retail ratepayer?
Sorry, sir, the question was, have we defined retail ratepayer in this?
What is the definition of retail ratepayer?
It's not defined in the statute.
Okay, would a small dry cleaning business be a retail ratepayer?
If the dry cleaner is paying an electricity bill.
Would a small manufacturing facility that uses electricity to run its processes be a retail ratepayer?
If it's paying an electricity bill.
So anybody that pays an electricity bill is a retail ratepayer?
Yes.
Does the author of the amendment agree with that?
I agree if they're purchasing that electricity from an electric, and actually a natural gas distribution company as well. Applies to both natural gas and electricity distribution companies.
So your definition of retail ratepayer is not exclusive to homeowners and condos and apartments. It includes small businesses and manufacturing facilities, basically anybody that doesn't have a direct industrial contract with the electricity provider.
That is correct.
Okay. I'll yield to Mr. Walden.
Thank you, Mr. Barton. That was the question I was going to go after. But what assurance, I mean, I appreciate your opinion, but what assurance do we have in statute? Is retail ratepayer defined anywhere in the statutes?
No, it is not.
So it is commonly assumed that that is anybody who pays an electricity bill or a gas bill under this circumstance will be considered a retail rate payer.
So long as they purchase it from a local electricity or, in the case of natural gas distribution company, yes.
What about situations like where you're, and I may be wrong on this, but this is all coming at us fast, like Bonneville Power Administration has DSIs. These are industries that purchase directly power. I believe they're allocated power directly from the Bonneville Power Administration. Would they qualify if you're a DSI?
I'm sorry, I missed the question, sir. Someone was talking to me.
It happens. I'm sympathetic
I'm
with
sorry.
it. A DSI is a direct service industry, so they purchase power directly from, I believe, Bonneville Power Administration. Would they be treated as a retail ratepayer?
I don't know.
If it comes from one of the power marketing agencies like TVA, Tennessee Valley Authority, or Bonneville Power Administration.
The bill, if I could...
Certainly, yeah.
Gentlemen, sorry. The bill itself provides for allowances to be distributed by, specifically by, natural gas local distribution companies and electricity local distribution companies. If these are ratepayers purchasing their power from those local distribution companies, they are considered purchasing retail power and are ratepayers pursuant to the amendment, and I believe the bill itself.
Right. So my question is are the organizations like Bonneville Power Administration considered a local distribution company for purposes of this act?
No, I can't be.
I would refer to counsel for the definition of local distribution company.
No, I appreciate that, yeah. So I'm just asking your professional opinion as counsel.
Because they're a generation company.
I think I understand the intent of the legislation and the definitional
Gentlemen,
intent.
yield.
Yes, certainly.
This is a power company purchasing from another power company. Is that
No. This would be an industrial user that purchases, I believe, directly, and I may be wrong on this, but I didn't have a chance to run this out in advance, directly from Bonneville, for example. And so my only question is, are these PMA, I think they're PMAs, public market, power marketing, are they considered an LDC for purposes of this act? Because I know it's your intent to do that, but I just want to make sure as we're legislating.
they distribute as well as generate the power?
They may, yeah.
The definition of electricity local distribution company appears on page 567. It means an electric utility that has a legal, regulatory, or contractual obligation to deliver electricity directly to retail consumers in the United States, regardless of whether that entity or another entity sells the electricity as a commodity to those consumers, and the retail rates of which, except in the case of a registered electric co-op, are regulated by a state regulatory authority, regulatory commission, municipality, public utility, or by an Indian tribe pursuant to tribal law. And that, again, is on page 567.
And so I'm sorry I got interrupted too, just a minute. But the last qualifier is that they are regulated by a public utility commission of some sort?
The retail rates of which, except in the case of a registered electric cooperative, are regulated by a state authority or some other type of regulatory commission.
Bonneville, I think, does its own rate-setting cases. So would they...
Gentleman's time has expired. I don't know that we can get a specific answer. The council will give us a further information to help us reach some conclusion.
I would be...
We're not sure whether Bonneville Power Authority sells wholesale or retail. If they sell wholesale, then it does not appear they would fall within the definition of electricity LDC, but we don't know Bonneville Power's situation.
Mr. Chairman, and I know we need to move this along, would the chair and the author of the amendment be willing to work with us on this? I assume it would be that you would want to include anybody that's selling power to a retail ratepayer.
Mr. Chairman, if I might, the gentleman's request relates not just to the amendment, but to the entirety of the bill itself. Because the question that you've raised about the eligibility of Bonneville for the allowances in question applies regardless of whether this amendment is passed or not.
Let me express my willingness to work with the gentleman, talk it through, and see if we can resolve any disagreements.
It's one of the reasons we're doing some hearings.
Yeah.
Yeah, I'd be willing to accept that commitment because I think I understand what you're trying to get to. I just want to make sure there isn't a group that's been overlooked by accident.
And I'd certainly be willing to work with the gentleman in
Thank you. We'll
accommodating
follow
those
up with
concerns.
the.
Mr. Chairman, we are prepared to accept the amendment.
The time has expired on the debate. The vote now comes on the space amendment. All those in favor of the amendment say aye.
Aye.
Aye. Opposed, no. The ayes have it, and the amendment's agreed to.